So, next po is kinds of dissolution, which are extrajudicial dissolution and judicial dissolution. Under extrajudicial dissolution, it's actually from Article 1830 po, from numbers 1 to 7. So, dito sa extrajudicial causes, titignan muna natin kung ano ba nangyari. Yung first instance dyan, kung nagkaroon ba or hindi nagkaroon ng violation ng agreement yung mga partners. So, dito sa number 1, I will explain more po mamaya after nitong kinds of dissolution. So, let's proceed sa pangalawa. Second is, dissolution is caused in contravention of the agreement between the partners, where the circumstances do not permit a dissolution under any provision of this article, but express will of any partner at any time. This is actually a cause where there is a violation po from the word contravention itself as an action that violates a law. So, for example po, A and B entered into a contract of partnership for a period of 5 years. If on the third year of the operation of the business of the partnership, partner B does not want to continue the business without any valid reason, then the partnership is dissolved. So, sa case na to, B is liable for damages because of breach of contract. Actually, pwede namang umalis na partner anytime po kung kailan niya ayaw na sa partnership. Kasi 'di ba nga sa previous topic about delectus personae that allows them to have the power, although not necessarily the right to dissolve the partnership. So, 'di ba nga ang partnership is based on mutual confidence. So, kahit walang valid reason or justifiable cause, pwede namang umalis. Pero yun nga, when the cause of the withdrawing partner is not justified by the other partner, magiging liable talaga for damages yung withdrawing partner. Basta tandaan lang yung principle na hindi nila pwede pilitin na magstay or manatili kung ayaw na ng isa, regardless kung anumang reason. Pero kung sa determination nila, kung unjustifiable yung reason, then pwedeng maging liable for damages yung withdrawing partner. So, yung mga next na extrajudicial causes po, yung 3, 4, 5, 6, 7, ito na yung mga tinatawag na causes of dissolution by operation of law. So, third is by any event which makes it unlawful for the business of the partnership to be carried on or for the members to carry it on in partnership. So, unlawfulness of the partnership's business po, madali naman pong intindihin. Example, a contract of partnership selling cigarettes po in front of a school. So, under Tobacco Regulation Act of 2003 po was enacted, absolutely prohibiting the selling of cigarettes near a school po. So, naging unlawful yung partnership. Yun lang naman po sa third cause of dissolution. Sa fourth naman, when a specific thing when a specific thing which a partner had promised to contribute to the partnership perishes before delivery, in any case by loss of the thing, when the partner who contributed it, having reversed the ownership thereof, has only transferred to the partnership the use or enjoyment of the same, but the partnership shall not be dissolved by the loss of the thing, when it occurs after partnership has acquired the ownership thereof. So, loss, tignan muna natin, loss of a specific thing promised as contribution. Kailan siya nawala? Kung loss siya before delivery ng item or thing, then the partnership is dissolved. So, bakit? Tandaan natin yung rule, ang tinutukoy ay specific thing. Kung lituhin man tayo ni sir sa quiz or exam, kung generic thing yung nilagay niya, hindi applicable yung rule na to. Kasi, pag nawala yung generic thing, wala namang effect. Kasi nga, di ba, pwede namang palitan yung item or thing as long as it is the same kind and value. Kaso, specific thing kasi yung andito sa rule. So, balikan natin. Kailan nawala ang specific thing? Nawala siya before delivery. Bakit pa di-dissolve yung partnership. Of course, partnership will be dissolved. Siyempre, hindi na ibigay ni partner yung contribution niya sa specific thing. Yun nga yung essence ng partnership by the contract of partnership, 'di ba? Paano naman kung nawala yung thing after delivery? Sino magbe-bear ng loss? Of course, yung partnership na yung magbe-bear ng loss kasi nalipat na sa partnership yung ownership or yung thing na deliver na. So, magkakaroon ba ng dissolution? Hindi. Kasi the partnership remains uh, kasi i-bear lang naman niya yung loss ng thing. Unlike kung nawala siya before delivery or before ng contribution ng partner, then dissolution will happen talaga. And another one po, if only the use or enjoyment of a specific thing is contributed and it is lost before or after delivery to the firm. Ito yung kaibahan. Kanina specific thing promised as contribution is lost before delivery. Ito naman, yung naibigay na yung thing. Yun nga lang, ang ibinigay na specific thing is yung use or enjoyment lang. So, ibig sabihin, meron na naman tayong ditong naked owner. Ibig sabihin, yung may-ari ng specific thing, ang binigay niya lang sa partnership ay yung paggamit ng specific thing. So, kung paggamit lang ang binigay niya, nag-reserve lang siya ng ownership over such specific thing. Yung magbe-bear ng loss ay yung partner na yon kasi siya pa rin naman yung may-ari. Yung dating, yung dating nito, wala naman talaga siyang kinontribute sa partnership. So, next cause po is by the death of any partner. So, if the partner dies, the firm is dissolved, but other partner can still continue. Yun lang sa death. Next, next cause is by the insolvency of any partner or of the partnership. Yung meaning ng insolvency dito, mas malaki yung liabilities kesa sa assets. In the case of insolvency, the credit is impaired and it is impossible to pay for partnership liabilities in case the partnership assets has been or had been exhausted. So, if partner is insolvent, he may no longer able to answer po for those liabilities when called upon to do so. Sa case ng insolvency ng partnership, that is because it results in the inability to continue the business. Which of course, pag di na continue yung business, that has the effect of dissolution. So next is by the civil interdiction of any partner. So what is civil interdiction? It deprives the offender during the time of his sentence of the right to manage his property and dispose of such property by any act or any conveyance inter vivos. One who has no capacity po to manage his own property should not be allowed to manage partnership property. So, yun. Next naman, so, nasa judicial dissolution na tayo. Next is judicial dissolution. Under this is number 8 of causes of dissolution. By decree of court under the following article 1700A and 1701A in relation to Article 1831 of the New Civil Code. So, in judicial dissolution, this may be ordered after hearing upon application. So, someone has to apply po, and who can apply is either a partner or a purchaser or assignee of a partnership interest. So, by application or for a partner. Under this is insanity of a partner. So, kung insanity ang ground ng dissolution, dapat i-prove muna sa court. Dapat court yung mag-declare na insane na yung partner. and pwede na maging ground for dissolution. And such insanity must materially affect the capacity of the partner to perform his contractual duties. So, next is incapability to perform part of a partnership contract. Another one is prejudicial conduct or persistent breach of the agreement. Bakit? Because the purpose of the partnership is materially affected or it is obstructed. So next ground also is the business of the partnership can only be carried on at a loss. Because the purpose of the partnership, 'di ba, at the very start is to earn money or earn profit. And yung purpose na yun is defeated. That's why this is a ground or a cause of dissolution. And lastly, a judicial decree may also be obtained for other circumstances which render a dissolution equitable. Some examples would be abandonment of business, fraud in management, etc. So, yan yung case or yung grounds for obtaining a judicial decree when a partner or someone on behalf of a partner who files the application. So, lastly po, 'di ba sa extrajudicial dissolution, hindi ko inexplain kanina yung first cause or first ground. So, kasi dito ko i-explain. So, in the first cause of extrajudicial dissolution, to explain it more, we have several grounds ng without violation of the agreement between the partners. So, first is by termination of the definite term of particular undertaking specified in the agreement. So, the termination of the partnership when the agreed period has arrived po, then it will cause dissolution of the partnership. So, a partnership with a fixed term po is yung may agreement na ng period or life of the existence of partnership. Example, there's a contract of partnership for 10 years. As a rule, after the expiration of 10 years, the partnership will be dissolved. So, partnership for a particular undertaking naman, it is one where it will exist until the purpose is accomplished. Example, a contract of partnership for construction of a building. After the completion of the building po, the partnership will be dissolved. Next ground is by express will of any partner who must act in good faith when no definite term or particular undertaking specified. Next, express will ng any partner. However, such partner must act in good faith when no definite term or particular undertaking is specified. So, a partner must act in good faith. So, natutunan natin sa obligation and contract na kung kahit sino pa siya, basta nag-act siya ng bad faith, he will be liable for damages. So, next ground is by express will of all the partners who have not assigned their interest or suffered them to be charged for their separate debts, either before or after the termination of any specified term or particular undertaking. For this ground, the agreement to dissolve must be unanimous po and not just be a majority, but yung consent ng mga nag-assign ng kanilang interest or had their interest charged is not necessary to affect dissolution po because their interest is no longer with them anymore. So, the interest in partnership. Yung remaining partners po in that case may simply dissolve the business. So, lastly po, the expulsion when the partner is expulsion. It is when the partner is expelled. Expulsion of any partner from the business bona fide in accordance with such power conferred by the agreement between the partners. In other words, the agreement must have granted po the power to expel to the partner, because if a partner is expelled po in bad faith, there can also be an eventual dissolution because there will be apparent lack of confidence. But also there may be liability in case of bad faith in such expulsion. So yun lang po, thank you.